ऐसे और वीडियोस के लिए इस चैनल को सब्सक्राइब करें। 3, 2, 1 start. Reliance was placed on the decision of this court in the case of Kaushalya Devi. The learned counsel relied on the observation made in para 11 at page 595 of the report and contended that the gravity of a complaint under the NI Act cannot be equated with an offence under the provisions of Indian Penal Code, and further urged that this court held that a criminal offence under section 138 of the NI Act is almost in the nature of a civil wrong which has been given criminal overtones. Reliance was also placed on the judgment of this court in the case of Mandvi Cooperative Bank Limited as reported in 3 SCC 83. This court in Mandvi discussed the scope of NI Act, including the first amendment to the Act inserted under Chapter 17 in the Act. This court looked into the statement of objects and reasons introducing the amendment and noted the rationale for introduction of Section 147 of NI Act. Section 147 of NI Act made the offences under the said Act compoundable. The court noted that from the statement and objects and reasons, it is clear that the Parliament became aware of the fact that the courts are not able to dispose of in a time-bound manner large number of cases coming under the said Act in view of the procedure in the Act. In order to deal with such situation, several amendments were introduced, and one of them is making offences under the said Act compoundable. This court fails to understand the applicability of the principle laid down in Mandvi to see the facts of the present case. It is no doubt true that Section 147 of the NI Act makes an offence under NI Act a compoundable one. But in order to make the offence compoundable, the mode and manner of compounding such offences must be followed. No contrary view has been expressed by this very court. On the nature of the offence under NI Act, learned counsel for the appellant also placed reliance on a decision of this court in the case of Damodar Prabhu as reported in 5 SCC 633. In paragraph 4, this court held that the dishonor of a check can be best described as a regulatory offence. The court also noted the situation that large number of cases involving dishonor of checks are choking the criminal justice system and putting an unprecedented strain on the judicial functioning. In paragraph 7 of the judgment, this court noted the submissions of the learned Attorney General to the extent that the court should frame certain guidelines so as to motivate the litigants from seeking compounding of the offence at an early stage of litigation and not at an unduly late stage. It was argued that if compounding is early, the pendency of arrears can be tackled. In paragraph 12 of Damodar case, this court dealt with the provision of Section 147 of the NI Act and held that the same is an enabling provision for compounding of the offence and is an exception to the general rule incorporated in subsection 9 of Section 320 of the Code. This court harmonized the provision of Section 320 of the Code along with Section 147 of the NI Act by saying that an offence which is not otherwise compoundable in view of the provisions of Section 320, subsection 6 of the Code has become compoundable in view of Section 147 of NI Act and to that extent, Section 147 of NI Act will override Section 320, subsection 9 of the Code. Since Section 147 of NI Act carries a new clause, this Court, on the basis of the submissions of the learned Attorney General, framed certain guidelines for compounding of offence under Section 138 of the NI Act. The Court held in paragraph 26 of Damodar that those guidelines have been issued by this Court under Article 142 of the Constitution in order to fill up legislative vacuum which exists in Section 147 of the NI Act. The Court held that Section 147 of the NI Act does not carry any guidance on how to proceed with the compounding of the offence under the NI Act, and the Court felt that Section 320 of the Code cannot be strictly followed in the compounding of offence under Section 147 of the NI Act. Those guidelines were given to fill up a legislative vacuum. Reliance was also placed by the learned counsel for the appellant on the judgment of this Court. Quashing of a case is different from compounding. In quashing, the Court applies it, but in compounding, it is primarily based on consent of injured party.